Hello everyone and welcome to our AI talk of December. My name is Aida Ponce del Castillo. I'm a senior researcher covering AI and its impacts on labor and law, and I am your host. Today we'll discuss with not one but two fantastic experts about the omnibus, the digital omnibus. The title is Whether It's Taking the Wrong Turn and Is the EU Weakening Our Rights? So today we have first Laura Lazaro Cabrera. Laura, she is the Counsel and Founding Program Director for Equity and Data at the Center for Democracy and Technology Europe here in Brussels. She leads also the work in promoting fundamental rights in AI policy and regulation and is closely working on the implementation of the AI Act. Laura previously served as a senior legal officer at Privacy International, where she researched data-intensive technologies deployed in the public sector and led interventions before the European Court of Human Rights and the Inter-American Court of Human Rights. So welcome, Laura. And next to her, we have also Daniel Leufer. He's a senior policy analyst at Access Now, Process also and dedicated to emerging technologies, and he is a policy lead of the field. His work focuses on the impact of emerging technologies on digital rights, with a particular focus on AI, facial recognition, and biometrics. Daniel, he has a PhD in philosophy by the KU Leuven here in Belgium. Thank you, Laura and Daniel, for being with us. And let's begin at the heart of our discussion today, the amendments that the European Commission Digital Omnibus proposal has put forward. You have the floor.
Thank you so much, Aida, for having me, and it's a pleasure to be here, and also alongside Daniel, whose work I have followed for several years, and who I'm happy to still see shaping the field. I'll just share my screen in a second. And let me just go into slideshow mode. Fantastic. I think you can all see my screen now. Great. So as Aida already introduced, I am the Program Director for Equity and Data at the Center for Democracy and Technology Europe. If you don't know us, we're an organization working to uphold and promote fundamental rights in European tech policy and legislation. Today, I'll be taking you through a subset of the changes that have been put forward as part of the Digital Omnibus proposal, namely the changes concerning the GDPR and that is the General Data Protection Regulation and the e-Privacy Directive. It's worth flagging, though, that the Digital Omnibus proposal is much, much bigger. Overall, officially, it amends 7 laws, it repeals 4 laws, but in reality, if you look through the details of the proposal, several other laws are indirectly impacted by the different amendments that are suggested. So I really want to drive home the point that this is just a snapshot of the changes that are at play, and Daniel will be taking you through the changes impacting the AI Act more specifically. But if you come away with anything from today, let it not just be that this is really a huge dismantling of our fundamental rights in the digital sphere, but also that this is just the tip of the iceberg, and the other laws that are being changed are also worthy of independent consideration. So looking specifically at GDPR and e-privacy, I'll start with GDPR really because I think it's a good way to understand the other changes that are coming through. And in terms of the philosophy underpinning the amendments, it's a good, I would say, a preview into why the Commission is acting in the way that it is and what the underlying rationale to many of these changes is. So explicitly, the motivation behind the Digital Omnibus proposal, and specifically the one amending the GDPR, is to put forward targeting amendments to boost innovation and support compliance, while, however, maintaining intact the core of GDPR and maintaining the highest level of personal data protection. We would be remiss to take the statement at face value. We've heard different versions of this statement from the Commission over the last several months, but as I hope to be able to show you through this presentation, what's happening really is a strong backsliding in terms of fundamental rights and specifically data protection. Funnily enough, the proposal addresses the fact that there is a fundamental rights impact caused by the amendments, but what they say is that the proposal strictly follows the principle of proportionality, and they cite Article 52 of the Charter of Fundamental Rights of the European Union, which says that any limitation on any of the rights recognized by the Charter, including the right to personal data protection, can only be limited where necessary and proportionate. So the Commission in the proposals tells us that they're following proportionality, but they don't explain how. And they don't go into the details as to how each and every single one of the amendments is compatible with a high standard of personal data protection. So I will leave you with this question mark for now. In terms of process, you will know that the proposal was presented on November 19th, following a leak the previous week, and that there is a consultation that is open for any stakeholder willing to engage until early February at least. And the date is being pushed back by a day for every single day that we go without having the proposal in all different languages of the European Union. So this is a moving deadline, but it's important to know that there will be an opportunity to provide feedback on the substance of the changes. Now, we're in a very difficult position because we haven't had sight and there hasn't been an impact assessment. The reason why there hasn't been one, ostensibly, according to the Commission, is the fact that the proposal is very technical in nature. But as I've already mentioned, this is far from being true. In terms of who is going to be overseeing this proposal in the next few months, we have at least two committees involved in the European Parliament. So the LIBE committee that works on fundamental rights and civil liberties, and the ETUI committee that works on matters pertaining to industry. There are many other committees in the European Parliament at the moment vying for some role in overseeing how this file develops, but these are the two that are most likely to be involved. And in terms of external oversight, we also know that the European Data Protection Board and the European Data Protection Supervisor, two data protection oversight authorities operating at EU level, will be issuing a joint opinion on the omnibus. In terms of timeline, we're still in the dark. There is no set timeline for this omnibus proposals. You will perhaps already know that this is not the first one, and indeed the only example that we have of a concluded omnibus process pertains to the first one, which had to do with sustainability reporting and environmental laws. And that one took 9 months from the moment the Commission was put forward, and then the proposal was finally agreed upon on plenary at the European Parliament level. So we're really looking at varying timelines here. Now, moving on to consider the main changes of GDPR, I wanted to take some time to hone in on the most significant one, which is the definition of personal data. So as you might know, personal data is a core aspect of GDPR because whether or not personal data is at play will define whether or not any practice comes within the scope of GDPR as a whole. Now, something that we need to acknowledge from the get-go is that the definition of personal data has evolved in the Court of Justice jurisprudence over the last few years. However, the amendment that has been put forward in the Commission proposal goes far beyond the state of the law for the time being, and indeed even might contradict some of the current validated and longstanding CJU approaches. So here, the proposed definition or the proposed amendment to the definition states that information relating to a natural person will not necessarily be personal data for every other person or entity, merely because another entity can identify that natural person. So in short, what we believe the Commission was trying to do here was to reflect some of the most recent jurisprudence. Many of you might have heard of the SRB ruling and many other preceding rulings, such as the Iskania judgment, for example, where they lean towards a more contextual approach of the GDPR and the definition of personal data specifically. However, the SRB ruling came with really, really strong safeguards and is not at all represented by the amendments that have been put forward. What the SRB ruling said, which is really deemed to be the cause of the proposed change for the definition of personal data, was that indeed, if an entity was given access, for example, to pseudonymized data with measures preventing identification, then it was not considered personal data for that entity. However, if that data is then transferred to someone else with the means to re-identify the data, the data is personal again. And this is an aspect that's missing from the core definition. What we can read from this proposed amendment is that a possible interpretation might be that just because personal data has been pseudonymized, just because an entity who receives it does not have the means to identify that information, it might then mean that this loses status as personal data for everyone. But this is not the case. What we should really bear in mind is that the state of CEU jurisprudence is that this is to be considered on an entity by entity level. It's not because personal data became pseudonymous or was pseudonymized that it's completely outside of the scope for GDPR for every other entity. This case-by-case nature of the assessment of what personal data is missing completely from the Commission's proposed definition. There are other, however, changes which are similarly, if not more concerning. So to start, the GDPR now would have reduced information requirements. So there's a proposed amendment to the article that deals with the information to be provided to data subjects upon processing of their data when there is a clear relationship between a data controller and a data subject. The controller's activity is not data intensive, and there are reasonable grounds to assume the data subject has already received the relevant information. So this essentially would exempt data controllers who already have some level of engagement with the data subject from furnishing them with necessary information as to the processing of their data. Additionally, in the case of processing of personal data for scientific research purposes, the need to provide information to the data subject is lifted, meaning that if anybody's processing data for what is considered scientific research, and we'll get to why that's problematic with this particular proposal, that means that they will have no obligation to notify data subjects of how their data is being handled. And this is a huge vector for data protection, transparency, and accountability. So this is something that's problematic for individuals to exercise their right to data protection if they don't even know how their data is being managed. The other significant change is the restriction on the right of access, which is now really only possible if data subjects have a clear data protection purpose when they're seeking to access information as to how their personal data is processed. Now, to start, the GDPR had always had some baseline level of limitation as to how this right was exercised. Many of you might remember that the GDPR already provides controllers a means to object to these requests or even request payment if the request is considered excessive. But the proposal that's been put forward goes even further by restraining the exercise of the data subject access request, which has been a huge avenue for individuals and civil society to know exactly what data processing activities are taking place, for this right to be diminished. Now, from a data protection and fundamental rights perspective, this is perhaps less concerning for the simple reason that this is a clear contravention of the Charter of Fundamental Rights. So the Charter explicitly says that everyone has the right of access to data which has been collected concerning him or her, and nothing in the Charter says that you need to have a reason, let alone a good one, to access your personal data. So this is probably one amendment that should fail simply because of inconsistency with the CJU jurisprudence. Next is the scientific research definition. So GDPR previously did not offer a definition for scientific research, even though scientific research itself was mentioned in the body of the law. And there is a new definition that's been put forward in the proposal, which essentially states that anything that benefits innovation, even if it promotes a commercial interest at the same time, is good enough to come within the scientific research definition. The proposal stops short of formalizing scientific research as a legitimate interest in and of itself, but the explanatory paragraphs definitely go in this direction. Now, you might say that scientific research is probably a good basis to be able to rely upon, except that now basically every big tech company, every industry actor that works on AI, for example, or on developing technology more generally, can to some extent argue that their internal activities bolster innovation just as they bolster commercial interests, and more specifically, primarily bolster commercial interests. So this is a very easy opportunity for lots of different obligations to fall through the cracks, simply because it becomes almost impossible not to be able to rely on the scientific research definition as a tech company. This has knock-on effects from the GDPR's perspective. For example, now other amendments, the new change to Article 51B, for example, state that further processing of personal data originally collected for a random purpose now will be considered compatible with the further purpose of scientific research. In addition, there's now a new exception that we had already discussed for entities or data controllers to give notice to individuals when processing of personal data is carried out for scientific research purposes. So effectively, this could lead to a situation where a company received personal data for one purpose. They did not notify the data subject that they wanted to use that data for AI training or AI development, and they would be able to now rely on the scientific research exception, so to speak, for further processing to be able to say we did not need to seek new consent and we did not need to inform the data subject of the additional purpose for which their data is being used, which is incredibly concerning and legitimizes the state of play in the AI training and development universe. A couple of other changes which are relevant to highlight. The default prohibition on automated decision-making is now removed. So now the text of the former provision is flipped on its head, and instead of being a prohibition and at the same time a right not to be subjected to automated decision-making, now we have a permission to carry out automated decision-making for three specific cases. These cases tend to be largely the same as they were before in GDPR. So instances in which the prohibition to process, to carry out automated decision-making would be lifted, except now there is some broader language inserted, particularly when it comes to contractual necessity. So formerly, contractual necessity was one basis which would allow the prohibition to be lifted, but now it's possible to lift it for contractual necessity grounds, even without having to consider alternative means to reach the intended purpose. That means that before, for contractual necessity purposes, ostensibly a data controller would have been asked to show that there was no other way to achieve the intended purpose unless they carried out automated decision-making. Now there will no longer be any need for them to show that no alternative was possible. And finally, I wanted to go to briefly mention the extension of the data breach reporting timeline, which has now been extended from 72 hours to 96 hours. A couple of changes that are solely focused on AI. These are the definition, first of all, the legal basis for processing sensitive data for the broad AI development and operation, and a new legitimate interest legal basis for processing personal data for the same AI development and operation, unless consent is explicitly required or this is overridden by individual rights. The first issue with this, starting with the new legitimate interest legal basis for processing of personal data, is that we now presume that processing for AI development or the operation of AI is a legitimate activity for processing of personal data. So for those of you who are familiar with the legitimate interest three-step test, you first have to show that an interest is legitimate, then you need to show that it is necessary, and then you need to show that when balancing the interest of the controller and of the individuals, the interests of the controller are right to prevail. If the interests of the individual prevail, they override the data controller's interest. And here we're simply doing away with the first requirement. We just assume that this is legitimate. This results in the loss of the technology-neutral nature of GDPR, which is ostensibly its greatest strength. With the AI Act, which Daniel will come to explain in a minute, there can be a debate sometimes as to whether something is an AI system or a general purpose AI model based on the quality of the definitions that have been put forward in the text of the law. However, with GDPR, a core safeguard was that it was technology neutral. So we needn't spend any time thinking about whether or not one particular definition applied or whether it didn't. This is a huge rollback in terms of the applicability of GDPR and the benefits. Another issue that arises when it comes to particularly the legitimate interest issue is the compatibility with the CGO case law. Here again, the CJU has repeatedly stated that in order for a data controller to be able to rely on the legitimate interest legal basis, they had to be able to show that they were compliant with the rest of the GDPR, including, for example, the obligation to notify data subjects of processing activities at the time of processing. It's interesting that we're now seeing AI development and operation being crowned as an always legitimate legal basis, where we don't know, or at least it's almost impossible to show that the companies processing data for AI training and development purposes are able in any way to exercise data subject rights. So this again is one particular change that will warrant further discussion and analysis. I am very mindful of time, so I'll quickly run through the e-privacy changes. The cookie provisions have now been folded into the GDPR, so moved from the e-privacy directive officially in order to address cookie fatigue and to centralize enforcement of the e-privacy directive within the GDPR. But even though the Commission describes this change as simply moving one piece of law into another for convenience, the reality is that they are not observing some of the previously held safeguards in the e-privacy directive. So the Commission says in its proposal, we still maintain consent as the main basis for processing data, and in particular access to data stored in terminal equipment, so devices. However, what the proposal does is actually broaden the instances in which consent is not needed. So the legal basis effectively, which will allow data controller to bypass consent, including first-party audience measurement, maintaining or restoring security, and fulfilling a service explicitly requested by a user. Of these, the audience measurement is particularly concerning, as we know that many data brokers will benefit from not having to rely on consent. Lastly, one positive addition, global privacy signals. So this has been something that many advocates have been fighting for. It essentially would allow the respect of automated consent signals, allowing users to reject content across all websites instead of having to repeatedly indicate that they object or that they consent multiple times. However, there's a small exception there. There's an exemption for media service providers. And in addition, this is subject to technical standards. So the nature of the global privacy signals that are likely to be enforced in this regard is up for discussion. There was an additional slide on implications, but I think I'll stop there and we can go into the knock-on effects of the GDPR changes in the discussion if folks are interested. Thank you.
Thank you, Laura. And we just continue with you, Daniel, and then we can open the floor for questions. Please go ahead with sharing your slides.
Great. Thanks a million for that. Can you all see my slides? Yeah. Super. So thank you to Laura for the excellent presentation on GDPR and e-privacy. And I would really echo what Laura said, that the scope of this is absolutely massive. And even in this current omnibus goes beyond the three laws that we're going to talk about, but is also just step one of a long process that the Commission intends to roll out of so-called simplification. Even on the day this was published, they launched more information about this digital fitness check, which potentially puts any law with a digital component up for grabs. So they're really undertaking an extensive process of completely folding to the worst excesses of industry lobbying. I think it's really disgraceful, the type of stuff that's being proposed, and unfortunately I think more is going to be proposed on top of that. So I'm going to zoom in a bit on the AI Act, and yeah, just for those of you who maybe don't know us, I work for Access Now, which is a global civil society organization that focuses on defending and extending the rights of communities and people at risk around the world. We operate a digital security helpline for communities at risk as well, should any of you need it. So what I want to talk about, yeah, again, I'll be mindful of time because some of the things could be moved to the discussion, but in general, a few comments on the procedure that's being used, although Laura already mentioned this, delaying obligations, what's kind of been referred to as stop the clock, AI literacy, fundamental rights oversight in Article 77, use of sensitive data, although this was already brought up, and then my favorite topic, transparency and documentation. So just as well, I thought maybe for some of you it's worth zooming out a bit and just say like what is the Artificial Intelligence Act? What is its potential value? It's a piece of product safety legislation, that aims to regulate the placing on the market and deployment of AI systems in the EU. What does it do for human rights? It has some prohibitions on AI systems that pose unacceptable risks, and I've listed a few of those there. But fundamentally, what it does as regulation is it provides transparency, accountability, documentation, and human oversight for high-risk AI systems. That's the bulk of what the AI Act does. There's other things. There's transparency requirements for generative AI systems, chatbots, different things. But like the meat and potatoes of the AI Act is the high-risk use cases. And there's a number of categories, 8, which are biometrics, critical infrastructure, education and vocational training, employment, workers' management and access to self-employment, access to essential public and private services, law enforcement, migration, and administration of justice and democratic processes. They are, as you can guess from those titles, pretty risky domains. So, the AI Act doesn't arbitrarily apply superfluous requirements to, the bulk of AI systems. And I think, a refrain that we heard throughout the AI Act negotiation process was that these high-risk domains are, they're not being considered bad things to do. We're not, the legislators are not saying, don't use AI here. The point was, these are domains in which if things are done badly, irresponsibly, then the consequences are severe. They're high risk for fundamental rights, health, and safety. So what the AI Act does, I always like to say, is it should provide a sort of a baseline of responsible development practices for these categories of systems. Again, set a floor for the market in the same way that, when I'm buying toys for my children, I look for a CE mark and I say, okay, maybe I can feel okay about this toy, that it's not going to poison or choke my child. The AI Act should do the same for AI systems. It's important to say that Laura already pointed to some of these things, but the stuff that the Commission says about the omnibus is nonsense. I would just say it outright like that. They're just saying things that are not true, and by saying them, they don't make them true. As Laura said, they say things about not lowering the level of data protection, but it does lower the level of data protection. They say that they didn't need to do an impact assessment because there's no impact on rights. I mean, again, it's I don't know who they're trying to fool, maybe themselves, but it's not working. And there's other aspects like this. The design, again, the quote I've highlighted here, it says they're designed to ensure the efficient implementation of rules that were already agreed at the political level, but they're actually changing political compromises that were highly contentious. And there couldn't be evidence of burden because these rules have not yet been implemented in the case of the AI Act. Okay, on the delaying the obligations, in this part, they're not actually talking about changing the obligations, but delaying the implementation. So for Annex 3 high-risk systems, which again is like the bulk of what the AI Act applies to, the categories I mentioned earlier, they're talking about a 6-month delay. It's important to note that if the negotiations on the omnibus aren't concluded by August 2026, then the obligations will actually kick in. So we could end up in an absolutely absurd situation where the original deadline will apply while they're still negotiating the extension to the deadline. I don't think it's by any means sure that they're going to achieve that. And I think, what they're doing as well is placing a high burden onto the Parliament and Council to accept the whole package to avoid the legal uncertainty of not having it sorted by then. Also for Annex 1 high-risk systems, so this is systems that, medical devices, things that already fall under other regulations, the date has been pushed from August 2027 to August 2028. This is highly problematic because, one of the main reasons being given for the need to delay obligations is that the technical standards are not ready. But the technical standards, from what we hear from people who are involved in the process, are not ready because they're being slowed down by industry. So you can see how industry is really winning here. They're arguing that, the standards are not ready for them to comply, but they're simultaneously the ones delaying the standardization process. And it's setting a very, very bad precedent to give in to that demand. Another part that's being changed is about AI literacy. So the obligation for providers and deployers of AI systems with regards to AI literacy is changed into an obligation on the Commission and member states to foster AI literacy. And this is quite big. You can see like the language that's used is that, it's crucial to equip providers, deployers, and other affected persons with the necessary notions to make informed decisions regarding AI systems. But actually, they're going to change that. So instead of an obligation, to just encourage providers to provide a sufficient level of AI literacy to their staff and other persons. This is really worrying because if people who are involved with systems don't actually understand how they work, then the impacts on the people who are affected by the systems are going to be massive. I've heard, and I'm sure you've heard as well, absolute nonsense from people who are involved in deploying systems, etc., about how they work, etc. I very recently, I won't name names, but from a huge company that is involved in AI, heard via that they said that large language models only make mistakes when there's mistakes in the input data. This was in the context of this company trying to sell the system to a government agency. There's a complete misunderstanding of how these systems work. And, if we don't have AI literacy properly obligated, etc., then we're going to have seriously bad consequences for how systems are deployed. Article 77 bodies, I think this seems subtle as a change. And, as Laura pointed out as well, there's a lot of talk from the Commission about the fact that these are targeted amendments, that they're not really going to have an impact on rights, but these like subtle changes in language can have a massive impact. So Article 77 is one of the most potentially interesting articles, I think, in the AI Act, especially, from the perspective of workers' rights, etc. What it does in the original is it allows, just so I can read it myself, allows national public authorities or bodies which supervise or enforce the respect of obligations under union law protecting fundamental rights to have access, shall have the power to request and access any documentation created or maintained under this regulation, etc., when that documentation is necessary for effectively fulfilling their mandates within the limits of their jurisdiction. So you can imagine here data protection authorities, you can imagine equality bodies, etc., who, in their investigations need to understand more about how these systems work, could go directly, I think, in our understanding of the original article, to the providers or to the deployers and ask for documentation. Now, in the original article, it said that they had to inform the Market Surveillance Authority of the member state concerned of any such request. What's changed in the new proposal, and it was worse in the leak that we saw before the actual proposal came out, is that they now have the power to make a request and access any information or documentation created or maintained from the Market Surveillance Authority. That's quite significant because now an equality body, for example, cannot go directly to a provider and ask. They have to go to the Market Surveillance Authority and ask if they're allowed to have access to the documentation. And again, small changes in language, but imagine administratively the type of bottlenecks that this can create. If the Market Surveillance Authority is already overloaded trying to do things, and I'll come back my least favorite amendment to one way in which market surveillance authorities are going to be massively overloaded by the changes proposed in the omnibus. Are they going to have bandwidth to actually deal with the request, and they have to go to the provider, etc.? The provider maybe comes back and says no. So it's creating a huge amount of additional administrative burden. I'll maybe skip over the bit about sensitive data because I think Laura already brought it up but it's definitely one of the.
You can go ahead. You can say it again, Daniel, because there are some questions in the chat about that. So it would be nice if you go ahead.
Okay, but yeah, I can't see the chat when I have my.
It's okay. We can take the questions afterwards, but will be because there are a couple of questions regarding whether there are safeguards from the board sensitive research clause, for example, for lawyers, doctors, journalists, insurance, and if it would be okay if you go again through the sensitive data stuff, no problem.
Okay, yeah. So, it's always been I think, a point of contention. It's not an easy topic about the extent to which, in some cases, it might be necessary to have access to sensitive data in order to mitigate bias. In a general sense, the issue is if you don't have any information about the people who are affected by the system, including like race, gender, disabilities, employment status, all of these things, then it is in theory difficult to understand where the biases may be there. So the debate has been that in certain specific cases, there may be need to have access to such data for the limited purpose of mitigating bias, etc. And that previously in the AI Act was in Article 10, Paragraph 5, and that has actually now been pulled out into a full new Article 4A on the processing of special categories of personal data for bias detection and mitigation. And it is, unlike Article 10.5 in the AI Act, providing a new legal basis for that, and also goes beyond just the limited case of providers of high-risk AI systems as well. And this is, I think, a complex one as well, because it has to be viewed in relation to the changes being proposed in the GDPR. And I think Laura did a very good job there of like pointing out, we have small change here, small change there, scientific research, all of these things, but the cumulative effect of these targeted technical changes is a massive potential impact on people's rights. And again, just to come back to the point at the start, the Commission saying that they didn't need to do an impact assessment because there's no impact on rights. It doesn't make any sense. And you can see how all of these small changes add up to a potentially massive problem. To go on to the next one. Yeah, I wanted to give a good bit of time for this one, because I think this is, I think the most serious and most impactful amendments are being proposed in the GDPR and e-privacy. But in terms of what's being proposed in the AI Act, I am still in shock that this has been proposed. I have said to many people, once we knew the omnibus was coming, I felt like an idiot on multiple occasions, because I said to lawmakers, to different people, that I was worried they were going to make this change. And every time I did it, I said, I think I'm just being really dramatic here. Like, no one could be stupid enough to do this. And here we are, here's the amendment, exactly as I was worried about. So just to give you a context on this, the original draft of the AI Act, you basically had a two-step process to determine if your system was high risk, and therefore if the bulk of these obligations kicked in. Two steps were, does your system fit the definition of an AI system? If yes, do you do one of the high-risk use cases listed in Annex 3? If yes, your system is high risk, follow all of the obligations. I think probably, the two biggest victories for industry, and not even just industry, but for the industry, maybe law enforcement, etc., lobbying in the AI Act negotiation process, was to add a third step into that process, where the provider, so the entity that is being regulated by the AI Act, would actually be allowed to basically ask them, but are you really high risk? So introducing a level of discretion into this, I think, objective process, again, a bit like what Laura said earlier, changing the definition of personal data from an objective definition to a subjective one. Across four very broad criteria, which think I listed them here. Yeah. So the 4 criteria are that the AI system is intended to perform a narrow procedural task. The AI system is intended to improve the result of a previously completed human activity, intended to detect decision-making patterns or deviations from prior decision-making patterns and not replace human assessment. And the last one is the AI system is intended to perform a preparatory task to an assessment. All of these things are hugely subjective and actually could have a massive impact on rights. You know, a narrow procedural task could be sifting through resumes or something. Now, there is another point in there that if the system performs profiling, then it cannot be exempted. But again, this is complicated by the changes to the GDPR and other reasons. But what we ended up with in the AI Act was a ridiculous loophole where providers could unilaterally decide, according to these 4 criteria, whether or not their system was actually high risk. What happened in the negotiations was there was an absolute bare minimum safeguard, which was that if a provider availed of this derogation, then they had to register the fact that they were derogating in the public database. So what you would have is you would see company A in Ireland decided that although they provide some kind of a pre-crime screening system for law enforcement, they're not actually high risk because it was a preparatory task. And, a little bit of their reasoning was listed on it. I'll go back. Can I go back? Yes. These are the things that they actually had to put into the register. And I mean, this is really not a lot of work. I can summarize this by saying numbers 1, 2, and 3 are just the names of the people involved, which is information that these people would have because it's information about their own names and addresses and things. The name of the system, which is pretty easy as well to copy paste. You're selling a product, it's the name of the project. A description of the intended purpose of your product, which again you would have because you're trying to sell it to people. The condition or conditions under which it is considered to be not high risk. Again, something you would definitely have to easily be able to know. A short summary of the grounds, and this is actually literally the only place where they have to think. A short summary of the grounds on which the AI system is considered to be not high risk. And the second one where they actually have to think, the status of the AI system, is it on the market? And any member states in which it has been placed on the market. This is like 10 minutes of work. It's information that they already have. And they've removed this obligation. So it's very hard to see what burden is being lifted, but what's happening is you're basically saying to providers, here's a way out where you can exempt yourself from the entirety of the obligations for high-risk AI systems. You don't have to tell anyone. You should prepare this information anyways, but don't do the, 6-click process of uploading it into the database. And I mentioned earlier, burdens being externalized onto market surveillance authorities. What I've heard from market surveillance authorities already about this is that they're now getting the full burden of having to go around and check who actually exempted themselves. But how would they know? There would be no way for them to know. And again, it's providing discretion where I think a responsible provider is, going to recognize that the AI Act has benefits, that their system poses potential risks and follow the obligations. An irresponsible provider is going to be able to say, I'm going to take my chances, opt out and not follow the obligations. And we're not going to have any possible oversight on this. So for me, this is really a red line. It's going to create massive legal uncertainty and have a potentially huge negative impact on people. It can also really, I think, disturb the market as well, because previously AI board, AI office, etc., would have been able to look and say, oh, in Ireland there was 1,900 derogations last year, and in France there were 4. There's some kind of an issue here. We need to investigate this. If this registration obligation is removed, they're not even going to have that level of oversight about how many derogations there are. I think I will stop there, but we can dive into things in the questions. Thanks.
Thank you, Daniel. Thank you, Laura, for this very, very detailed presentation of both the amendments to the GDPR and the AI Act. It does impact society massively. And as many people are also here related to the labor concerns, I just want to very, very quickly say that yes, all of the amendments have an impact on the workplace, because workers as citizens have the same impact. So indeed, for the automated decision-making system now, it's going to be very easy for employers to permit to allow automated decision-making systems, fully considering that there's a necessity for a performance of whatever contract, even if a human decision, it would be possible. That means that employers can actually frame automated monitoring or surveillance, rating, scoring, or even disciplinary systems as contractually necessary default tools, without really strengthening any transparency or constatability safeguards for workers. So it's going to be super difficult. So also the amendment on the access on rights and the weakened transparency will also narrow or decline the individual or collective access requests, including those access requests supported by trade unions or by other NGOs. So it's going to be also another reduced in transparency for workers, and their normalization of collecting sensitive data in order to process that in AI systems or for AI databases will be possible thanks to this derogation of Article 9 of GDPR. So again, yes, as Daniel and Laura have said, combined together these micro changes or massive changes, this will normalize the use of sensitive data in algorithmic management systems for many purposes and with many cumulative effects. So now the floor is yours. We have the opportunity to have together Laura and Daniel here with us, and please just type your questions in the chat, and in order to have a very nice discussion. But Laura and Daniel, if you want to react quickly to one or two things while we organize the questions, please go ahead.
Just one reflection for me on the presentation that Daniel was giving.
Mm-hmm.
He explained the circumstances under which the proposed amendments to the AI Act will broaden the scenarios for processing of sensitive data. And the funny thing is, many of the changes in GDPR are tied to the development of AI, but they go way above and beyond what the AI Act actually requires, even with this proposed version, which exaggerates the level of sensitive data processing that needs to happen. So it's interesting to see that the GDPR has created a broader license for the processing of sensitive data than the AI Act would think is necessary to fulfill the objective to promote AI innovation. So if the Commission's intention was to better align these two pieces of legislation or make them speak to each other better, they completely overcorrected by broadening the basis for processing sensitive data in the way that they did the GDPR, which shows a little bit of for me, cognitive dissonance, but also might show that the interest might be to go beyond even what was already allowed in the AI Act.
Interesting reflection, Laura. Let's go to one question here from the audience. I would like to pick the question from Natalia Georgi from ETUC. She thanks you both for this very nice presentation. And in her understanding is that both proposals are part of a package, but they are not related in the sense that the amendments proposed will be addressed by the European Parliament and the Council in parallel. Is that correct?
Yeah, I can go if you want. Yeah, so they will be negotiated in parallel, and there's, now going to be the process of committees in the Parliament are vying for sort of their piece of the pie. And then within committees, we're going to have political groups also trying to find out who will get rapporteurship, etc. That is going to be complex. For the AI Act, that process took 6 months, I think, which was unusually long, and it's unlikely that it would take this long. But I think a huge amount depends on how those competencies are divided among the Parliament. What we saw with the only omnibus that has actually got through the process, the sustainability, was that EPP sided with the far right, which was unprecedented and extremely worrying. And so that again could be on the table, which would be disastrous. So a huge amount depends on which group actually gets it, which committees, and then within the committees, which group. But there's also, the whole narrative that they're presenting about this creating legal certainty, etc., is nonsense, because you're going to have changes happening in the two files that are not necessarily coordinated, because it's going to be, if they're both being negotiated at the same time and there's trilogues, like the potential that actually the two things go out of alignment, like Laura just said, it's the GDPR could get much worse and allow much more than the AI Act is intended to allow, etc. So yes, they will be negotiated by different, sometimes overlapping people at the same time, and not necessarily in a manner that is aligned. Sometimes I like to say that the lobbying that is being done on some of these laws is, sometimes it's confusing. It's so bad, what the changes that are being proposed, that it's hard to see how it will benefit anyone. But sometimes I wonder if the purpose isn't to just make EU laws look ridiculous for an international audience. And if that was your goal, then I think the omnibus is definitely going to potentially achieve that.
All right, I have a question related to that, to the Parliament handover. And if you might know, Laura and Danielle, there is this report from the Parliament calling for a directive on algorithmic management at work, which pretty much it's the continuation of the Platform Work Directive and the completion of the AI Act in a way, so that workers are protected when they are exposed to AI systems. So, as you know, this is an initiative report by a rapporteur of the EPP. Can you perhaps tell us, how do you see these both initiatives in parallel? On the one hand, this initiative calling for a more specific protections for the workers, labor aspect, and on the other hand, the omnibus with the amendments that are really cutting the core of fundamental and labor rights as well. What's your opinion about that?
I can come in quickly on that. Unfortunately, what we hear from Parliament is that there is very limited appetite to regulate on any field. I would be hopeful that when it comes to labor laws, because there's such a rich history of European legislation covering labor concerns, and there has been such sustained advocacy and attention by trade unions in particular, that it's too soon to give up, basically. But even though it's very clear that additional protections are needed for the workplace, I mean, from my knowledge, the AI Act tried to do a little bit, but it didn't go nearly far enough. Even though there's a consensus that there's more needed than what's currently on the table, it might be difficult to see those changes through. And we might see the same narrative that has emerged, for example, in regards to the Digital Fairness Act, which is being discussed at the moment, emerge in relation to specific changes having to do with algorithmic management. So I think certainly the current landscape doesn't indicate that those efforts are likely to be too successful, or at least that there's a lot of political will behind them.
Thank you, Laura. And just related to that, what are your thoughts about what actually still remains protected in the EU? Claudia Roda says that it feels like there are so many ways around the original GDPR requirements that personal data are completely up for grab.
On that one, I mean, I can say indeed that the GDPR is on the verge of being completely gutted, but I felt somewhat more comfortable after the official version of the omnibus was published following the leak, because the leak actually went even further in some respects, and it proposed a change in definition for special category data, so sensitive data. And according to the leak, sensitive data was limited to information that directly revealed special data categories, which obviously would have completely undermined the whole purpose behind that particular provision, which was to be able to capture inferred sensitive data. And luckily, we didn't see that in the officially the public version that was published on the 19th. So it could have been much worse in that regard because I would have completely undermined one of the core protections of the GDPR. And I'm also very happy to see that the principles of data protection haven't changed. So I was really concerned to see changes in purpose limitation. Granted, that there's a bit of weirdness going on now with purpose limitation now that we have that scientific research provision, but at least data minimization still stands, lawfulness, fairness, accountability. So I think it could have been much worse indeed.
Maybe one point on that as well is just, Laura already mentioned this, the charter is there, and if like the stuff we saw in the leaked version of the omnibus was a lot worse, but there's potential as well for during the negotiating process, depending on who gets the rapporteurship, etc., as well, that where even worse amendments could be proposed. And I think it's going to be essential to look at other avenues to push back against some of these changes if they're clearly and flagrantly in violation of the protections that are there in the Charter.
And clearly, for automated decision making, Daniel and Laura, what exactly can people do in order to prevent this from happening just because of a matter of a necessity?
Do you mean aid in terms of advocacy?
Yes, sorry, yes, in terms of advocacy.
I think it's really important to underscore that this is about fundamental rights, and this is about things that everyday people can rely upon when it comes to their interactions with private sector entities. I mean, the right not to be subjected to automated decision making, I didn't talk about it in great detail, but the reality is that that's, in my view, much better than what we could have under the AI Act, exactly because there are so many gating issues as to what's an AI system, does it rise to the appropriate level of risk. So if you are cutting down on these core prohibitions and core rights, and yet what you're directly doing is undermining the safeguards that exist for individuals to enjoy, and you're fundamentally changing the nature of individual relationships with digital spaces. So I would say definitely going down the rights route is the right way to go, instead of getting lost in some of these technical debates about, what's worth sacrificing or compromising. In the end, you're removing a right. I think that's where the conversation should stop.
Thank you. I'd like to pull the question from the Green European Foundation, and she also, the person also thanks for the nice presentation. And she's very new, the person is very new on the topic, so it might be a quite simple answer, but what was the main motivation for the changes to the GDPR and for AI innovation specifically? Is it mainly related to training on data sets and getting more access here, or also related to usage, privacy, or ChatGPT, for example?
My understanding, reading between the lines, of course, because this is not something that would make it, I think, to the proposal officially, is to make it easier for companies to be able to process data for AI training. The reality is that the way that EU law is at the moment when it comes to data protection, it doesn't prohibit. I mean, in one reading, it might. In my reading, the way that AI models have been trained is completely unlawful with regard to the GDPR, but this is now becoming a very fringe opinion, and more regulators even are going in the direction of it might raise data protection concerns, but it could potentially fall the processing of personal data for AI training could fall under one of the legal bases under GDPR. And the one legal basis that's been seen as being the most likely to validate this is the one on legitimate interest. But it hadn't been said before conclusively or in a way that was binding that the legitimate interest legal basis was the one to which AI training could be legitimized. So indeed, there was that open question, and now what the proposal is seeking to do is, I would say, persuade or comfort AI developers that indeed they're not likely going to face liability for having scraped lots of data online and having used it without having sought the consent of data subjects or even informed them of their rights under GDPR. So we think it's to reassure private sector more than anything else.
I think as well, there's an element of opportunism as well, where, with the Draghi report, with all of the focus on innovation, etc., a lot of people have wanted to attack the GDPR for a long time. And this is a convenient wedge to get in there. But I think the process is extremely dangerous that's been opened. And we've seen calls for a full overhaul of the GDPR into a risk-based model in line with the AI Act. So I really feel that this is being used as a wedge to get in there for a lot of other reasons.
Now that we're talking more about GDPR here, Pauline Dubois, she has a question for you both. What do you think about the amendments on GDPR of Article 13 and 14?
I think these are the amendments having to do with information provided to individuals upon processing. I think these are terrible. And honestly, a part of me also thinks that this might be a way to curtail some of the civil society work that's been done. So for the rest of the audience, these are some of the changes that I mentioned on the whether or not the data controller could refuse an individual's data subject access request. Because to me, when they try to tie the subject access request to the protection of data, some of it really tells me that what they're really trying to curtail here is some civil society activism and research that has happened over the several years where organizations have had some of their staff, for example, use certain products or technologies to test them and then use the data subject access request mechanism to gain real insight as to how data was being processed and whether or not, for example, the processing was compatible with what was set out in the privacy policy. A lot of civil society organizations have done a lot of meaningful research over the years using this mechanism. And I can't help but feel that now that the purpose is specifically tied to the protection of someone's personal data, that they're trying to make sure that this is really done for someone's personal and private benefit of knowing what happened to the data, as opposed to something being used as the basis of a bigger investigation or reporting more generally. So I think this is very blatantly reducing the vectors for accountability for no good reason, because again, GDPR already gave data controllers the opportunity to take action whenever a data subject access request was deemed excessive or I think manifestly unfounded. So I struggle to see why this was necessary, to be honest.
Daniel, would you like to add something?
No.
It's okay. And I would like to take the question from Vanessa Di Palma. She is asking, is there any carve out or safeguard from the broad sensitive research clause, for example, for lawyers, doctors, journalists, insurers? She asks because the risks that this might create might be a backdoor, compromising confidentiality.
I think this might relate to the scientific research broadened definition under GDPR. As to how the scientific research potential basis for processing relates to professional secrecy obligations, I think this is a member state issue and something that's worked out at the national level law. I don't think the GDPR navigates these tensions or overlaps, but both of you feel free to come in if I'm missing something.
Well, I think that the last question so far, and it's for both of you, it's from Nick Mock. Could you, in general, explain how is it possible for the omnibus amendments that can happen even when the law is already voted? How is this democratically possible?
I mean, I think it shouldn't be. I mean, with the AI Act, it's specifically egregious, I think, because the thing hasn't even been implemented properly yet. So there's no potential evidence of negative impact or problems with it, etc. But it seems quite clear that a tool and a process is being abused. I spoke and Laura spoke as well about just these nonsensical statements that are being made. These are not targeted adjustments, etc. So hopefully some of the, I think there is a possibility for pushback against the way that this tool is being used, because it sets an extremely bad precedent. Just basically turning around to the parliament and saying, here's stuff that you had fought very hard about, and here just on the table again, change your mind. So highly opportunistic.
Just because it's really the last question, Laura and Danielle, and I think it's very interesting too. It's related to the US. Do you think that the newly released US national security strategy will influence policymaking within the European Union? And if so, will it push the EU forward, loosening guardrails and accelerating development, or towards greater caution and regulation instead?
I mean, what can we say about that strategy? I have to say I was equal parts outraged when I read it, but also in a way, I think it's such a blatant display of intention to interfere in EU affairs that my hope is at the moment that it will generate backlash from our decision makers and our representatives as opposed to submission. That's all I can say.
Perfect. Great. And with that, I'll thank you both, Daniel and Laura, for this fantastic intervention. Thank you very much for your time. I know you're very busy. If you'd like to say something now, it's the moment. Otherwise, we close and we thank you, the audience, for being with us with another AI talk. This is the final AI talk of the year, and I hope that we can have very interesting conversations. Thank you, everybody. See you later, and goodbye.
Thank you. Bye.